Next question is whether or not teachers can sell their lesson plans and their curricula and that sort of thing. And this is actually another really interesting area of copyright law because it's just kind of an emerging area. Now, when you do that, you have to click back into the slide so my click will work. Yep. So here's our hypothetical. Oh, I love this cartoon. I don't know if you can.
Darn it.
Yeah, no, they can read it because
Okay.
they aren't seeing where our box
Okay,
is.
gotcha.
Yeah. So school administrators require a teacher to develop lesson plans, which you all should do. The teacher spends 20 hours of her own time at home developing thorough and intricate plans. As the year goes along, she thinks, wow, Madeline Hunter was right. Good planning leads to good instruction. How amazing. So she thinks that since these lesson plans are so awesome, she's going to make a few dollars by selling them on Teachers Pay Teachers. Question is, can she do that? That's the entire section that we're going to talk about next. And this is, like I say, this is an emerging area of the law that you should be aware of. You may have teachers selling stuff on Teachers Pay Teachers now and not even know it. I love this cartoon. So the answer to this hypothetical question is all driven by the work for hire doctrine. And the work for hire doctrine basically says if you pay someone to prepare intellectual property, that person doesn't own the sweat of their brow, you do, right? Because you, the employer, have paid them to create that work. So this is exactly the language from the United States Code. In the case of a work made for hire, the employer for whom the work was prepared is considered the author for purposes of this title. So if you tell the teacher to create the lesson plans, then the school district owns the lesson plans. Unless the parties have expressly agreed otherwise in a written instrument signed by them, and that's going to be the question, have you given any rights to the teacher in their contract or in the collective bargaining agreement or anything like that? So this is the default. The assumption is everything a teacher prepares while they work for you, you own. Because you specifically told the teacher to create the work, clearly that means that the school district owns. And again, this most often arises in the employer-employee relationship.
We're going to have 4 cases here in a row. We're going to burn through them pretty quickly. But as we talked about, the 2 elements for proving copyright violation, the first one is ownership. That's where this works made for hire stuff comes in. So the Roop versus Lincoln College case lays out the factors pretty well. And essentially, there's a 3-part test. Was the work the type the person was employed to perform? Did it occur substantially within the authorized time and space limits of their expected duties? And was it created at least in part by a purpose to serve the master? What happened in this case is Roop was a college teacher asked to essentially develop an entirely new program within one of their colleges for like a tourism, sports entertainment sort of major at this college in Illinois. She went to all this work. She went and got a graduate degree at the insistence of the school. So essentially, it's very similar to saying to that teacher, you need to go get an additional endorsement certification and putting that in the contract. She signed all that. She develops this. They are upset with how essentially she's been performing. And they tell her, okay, we want you to do all of these things. You need to go do some additional coursework. She doesn't do it, says, I quit. Her argument is all that stuff that I developed for the purpose of that new major, I should get to keep because that's mine. The college's argument is you were clearly doing it to the extent that you were engaged in your official duties. And really, the test came down to a series of emails that they had exchanged in which she had been asking questions of her supervisors related to the development of this curriculum. So they said they both had good arguments. She did work outside of her expected duty time on it, but she also asked her employer questions about whether it was good enough. This case is exactly what I think having to submit lesson plans is a good idea, even if it's just occasionally, because it evidences your intent as the school to say that that was part of your expected duty. So in this case, Roop loses. We go to the Pavlica case, opposite result. Pavlica is a science teacher in New York who develops essentially this research-based science curriculum completely on his own in the mid-90s. As a part of that, he did not ask the school, should I create it? He did not ask them anything. And in fact, when the Board of Education was updating its science curriculum, they asked him to come in and pitch the curriculum that he had developed. The board picks his curriculum, ends up paying him for his curriculum, evidencing again that he has actually maintained ownership of it. Where this got sideways is he had some guys that were working for a college that said, hey, you've got a moneymaker here. We'd like to start selling this all over the country and have you go train people. So this college pays this high school science teacher to do that, essentially to peddle his program throughout the United States. They get grant funding, everything's going well, and all of a sudden Pavlik is like, why am I sharing this with you? So he tells them cease and desist. The school in this case actually comes in and says, yeah, actually, we think Pavlik owns this. We believe that we paid him for it. We didn't ask him to develop it. And so because they had established those clear parameters saying that Pavlik, I think this is yours. You did it on your own time. You didn't start using it in school until we approved it as a board. You own it. So the court says this is outside the scope of employment because the time spent on it essentially was outside of his course and scope of his duties.
Notice on the third bullet point when it says he did not attain approval to create the program, and I think the most important part is the last three words, and he did not use it in the classroom.
That's right.
I think the whole thing could have been different if like the classroom was his test bed to see if this was good or not, which is typically what we see happening with new stuff that's developed by our school district employees.
Yeah, I think that the Roop case compared to the Pavlik case, what they show is if it's something that's going to be used to complete the duties, absolutely, I think you should argue that it's a work made for hire. We're fairly aggressive when we talk about that stuff. The last case is Shawl. This is a case similar to what Karen talked about earlier. Shawl is a real dirtbag, to be honest with you. In 1990, he is convicted of having an inappropriate sexual relationship with a student, somehow gets only probation and continues teaching at this school. Then in 1999, he develops another inappropriate relationship with a sophomore girl who's been assigned to his homeroom and gets convicted of stalking her. Now this guy there's no way he's surviving past the 1990 incident nowadays, right? But this guy is still there teaching, fighting to teach another day. By the time the school eventually says, all right, sexual assault, stalking, that's probably enough. They functionally cancel his contract. They have 2 administrators and 4 custodians go in and clean all of this stuff out. His argument is that what they gave him back did not include a lot of materials that he had been preparing to use in his class. And so he's essentially saying, I've got a work made for hire. So he files a lawsuit when those lesson plans and things weren't returned to him. By the way, one of the things they did return to him was he had created, during his time at school, 2 picture albums of these girls. This is like a super creepy case. So I think this is one where the judge comes down on it pretty hard. But I think the combination of the Roop and Pavlik cases leads to this court saying, look, if you're motivated to spend time to prepare materials to fulfill your duties as a teacher, regardless of whether you wanted to sell them on Teachers Pay Teachers or peddle them to another school at some point, if your primary motivation was to have a better class because of them, those are owned by the school. The important part is the very nature of the teacher's duties involves time outside of the classroom. So he makes the arguments that they've not made in those other cases. What about at night when I'm doing things at home? The court acknowledges, because the administrator said that's an expectation. You're an exempt employee. Of course you're going to grade papers and do things like prepare your lesson plans for the next day or the next weeks at night outside of your instructional time. That's an important part that teachers don't understand. Leaving the building doesn't make them any less a teacher if their purpose for what they're doing is to carry out their duties.
And I listen to a lot of educational podcasts. I follow a lot of educational Twitter accounts. And this second bullet point, the third bullet point up here, the nature of teachers' duties involves time outside of class. That idea is completely lost on these podcasts. I have heard people that I respect that are, educational heavy hitters say, if you want to sell what you're developing, make sure that you're doing it at home. That is not the test. The test is it part of your duties as a teacher? Then I don't care if it's 3 a.m. and you're, in your car using a privately owned laptop. If you use it the next morning in class, it's very likely a work for hire. That's just I just hear that a ton. Well, do it mostly on your own time and then you'll own it. That's just not true.
Yeah. If you were all sitting here and we said, show of hands if you think you've had teachers sell lesson plans or buy lesson plans on Teachers Pay Teachers, I bet all of you and administrators would probably, I bet that has happened. And if you asked your staff, definitely it would have. Ask and think to yourself, how many times did they get a written agreement from the Board of Education to sell that on Teachers Pay Teachers?
Because
you got your answer.
They're selling school property. They're
right.
selling like extra textbooks online to make money on the side. That's what functionally they're doing.
All right, we've got one last case on the work for hire. This is a 2017 case out of Illinois. What we had here is a plaintiff was the computer lab assistant for 12 years, and on her own, in 2005, she develops her own program. They didn't do a very good job of explaining what the program was, but it seemed to measure the tendencies of some things that occurred in her classroom. So she had developed it 2 years earlier before she started using it in the classroom. The school had no idea she was using this. In 2008, they figure out she's doing it, and they said, hey, can you rewrite that and give us regular updates on that program? And they incorporated some attendance provisions and things like that. So they used it for about 7 years without any issues. In 2015, they told her, we're not going to use your program anymore. We're going to buy a more sophisticated commercial program. Well, the plaintiff asked for a copy of it, took a look, she says, well, this is just a reverse engineered version of what I was providing to you. And so she quits and sues them for copyright infringement, and the school filed a motion to dismiss. The school argued it was a work for hire, and they owned it. The plaintiff says it couldn't be a work for hire because I created this at home, and the school wasn't even aware of it for 2 years when I was using it. The school's response, and I think rightly so and smartly so, was, okay, forget about the 2005 version. That 2008 version, we did take control, and we did direct her how to complete that programming to give us updates. And so the court said the 2008 version was a derivative work, but they said, is it a work for hire? They looked at different factors. The plaintiff said, hey, I had close control over actual updating of the program, even following that 2008 rewrite. And it could have been written off school grounds, favoring the school. It was a 12-year employee. She wasn't paid anything extra for that program. She was getting all the benefits that an employee would get. And the district in their contract had an authority to assign additional duties, which would obviously include rewriting and updating that program. Court found in favor of the school. They said they didn't talk about the 2005 piece, and I think the school probably would have lost that. But the 2008 program, they said, is a derivative work. It's owned by the school, and they have the copyright, at least partially.
Okay, so if we go back to the statute, I told you that the assumption is going to be that the school owns anything that the teacher puts together, unless, and you see the highlighted language here, unless the parties have agreed in a written contract that we're going to share rights or we're going to do something differently with the ownership rights. And so we want to circle back to this because the question now is, what does the written instrument say? For the most part, we don't think that your standard teacher contract includes the right for teachers to sell or share lesson plans on the websites, again, because you own them. Especially when we use professional learning communities and workshop days and curriculum committees to like underlie all of the work that teachers are doing. This is obviously a humongous investment of public resources in the quality of these plans. So having teachers just sell them, they're giving away school property, and I just don't think that is consistent with the law. It's certainly not consistent with the idea that you cannot give away publicly owned things without the permission of the board. So this is the common wording that's in most teacher contracts, something like this, that the teacher agrees to devote his or her full time during days of school to the position in all respects and to perform all of their assigned duties diligently and faithfully to the best of their ability. That's probably enough to cover everything educational at all that the teacher does. And then obviously we can enhance that or detract from that by a school policy or by a different specific kind of contract. Some superintendent's contracts include wording that the superintendent can do speaking and writing on the side. That is going to then change the analysis a little bit. It's going to be what's on the side and what's part of the contract.
And whether it says with approval of the board or not, you can see now that's of legal significance based on the materials.
Because if the board hasn't given approval, then the assumption is that the board owns it. And if the board has given approval, then we're going to have to get into the weeds about who owns what people are doing on the side.
This is our policy.
So this is our specific policy that limits the ability of staff members to give away the stuff that we own. It says that works created by district employees are owned by the district. I think that's fair. I don't think it's being a jerk to have a policy like this. I think it's fair to tell people, hey, we own this stuff. We can enter into a written agreement with a staff member allowing them to share ownership. So if somebody comes to you and says, hey, I've got this great idea, it's really smart to do some kind of little written agreement that says, okay, we'll own it 50-50. And that's not you screwing the teacher, that's actually you protecting the teacher, because otherwise the teacher gets nothing. So doing an agreement, sometimes I think we feel like we're being greedy gimmies, but what we're doing is protecting the teacher. Then the board will only enter into the agreement if it's something that we should have to pay for. It's separate and apart from what we require everybody else to do. Then this last paragraph is something that I put into the policy years ago when we started doing distance learning courses across the state. I wanted to make sure that nobody could claim that if you are in Ogallala and you're receiving chemistry from an Omaha school, that there can be no argument that that's a copyright violation because we're sharing it for an educational purpose. So we have in our form policy, or had in our form policy for years, that the board would grant other educational institutions a non-exclusive license to use their stuff which again would cover Ogallala streaming chemistry if it had been scheduled through Renovo or ESUC or whatever. And so I thought this was in everybody's policy book. I have discovered recently that although I think it's brilliant, not everybody was smart enough to do what we said. And so this was the beginning, and now we're going to have Beth come in and talk about the next movement about this, what's a work for hire, because we want to be able to share stuff on the OER comments. So I'm going to pop out.
Yep, this is just the stuff that we already talked
about. Yeah, if the contract's silent, assume it's ours. Yeah, I don't think that's vital. Okay, so I'm going to swap out.
Yep, Beth's going to come while we're doing that. Basically, what we concluded after looking at policies across the state and at various ESUs is that not everybody had a uniform policy or even close to uniform with respect to the ability to share and exchange and collaborate on curricular materials or other education-related materials throughout the state. We'd always had that in our policy, but I think because of this work made for hire concept, it was important to us that if we're going to use something like the OER Commons, which Beth will describe here in a second, that we had something for boards to consider which highlighted what it is that they're actually doing with respect to these legal rights. So it's a small portion relative to what I think Creative Commons and OER Commons could be, which is awesome. But I think it's important for boards, at least because of the requirement that they have a written authorization to share things like a lesson plan for a staff member, that we designated. So I'll just turn it over to Beth at this point, and she can kind of take you through a little bit of this, maybe the bottom part in particular about the
Right.
license.
So, and kind of to give a little background of how this all started, the Department of Education is really looking at the standards that they're producing or that they're sharing and developing, and then what resources or what lessons or what units are created to, high quality units that are created to match then our Nebraska standards, and how can we share those high quality resources or curriculum across the state with all of our classroom teachers without having to worry about work for hire. So the OER process then that's how it was not created, but considered as an initiative that the ESU organization was involved or partnered with our Department of Ed. So through all that, then we had a conversation with KSB Law to say, most of these copyright policies are really not allowing for our teachers to host or post any of their works to be collaborated on or to be shared through OER Commons. So what can we do about that? So therefore, this is an example of a type of policy that could be adopted. And what Bobby is sharing at the end, you'll see that Creative Commons has, 6 types of licensing. And those are the ones that are probably what we want to do in terms of anything that we create, and we are allowing our teachers to post in this type of platform, that it is both non-commercial and share alike. We're also maybe suggesting in some cases that are developed by our Department of Ed that are no derivatives can be made. So what non-commercial, obviously I think all of you are okay with that. The share alike simply means that if I take something that Bobby has created for my class and he has licensed it under Creative Commons with share alike, then I have to also include him as a creator of that resource. I can make, if he just says that it could be non-commercial and share alike, I can make derivatives of that resource, but I have to continue to share it or license it in the same original way that Bobby had licensed that particular work using Creative Commons. Now, again, as we said, for the derivatives piece, maybe your district is working on some curriculum and you want to share it, but you want to make sure that is done with fidelity, and so therefore no derivatives can be made, or it would not be the license that you're posting on there. So that's pretty much how that all works in terms of how we want to share it. And so this particular policy, in my opinion, kind of reverses the process that Karen was speaking about before, saying that if I wanted to share something or go out, I would have to have approval from my district. This really says that your district or you as administrators are saying, all right, teachers, we know that you're doing this work under our work for hire policy, but if you are going to share this in an OER format, then this is the licensing that we would request that you share it, and you do not have to have approval from us.
Yeah, the way that I envision it is teacher creates a brand new organic lesson plan based on part of your curriculum. This policy says to that teacher, we as the board have made the decision that participating in OER Commons is a good thing, that we want to not only share the benefits with other schools of our teachers' awesome work, but maybe we can receive that benefit back in another area where a teacher doesn't have a lesson plan, or we want some other type of material. What this would allow your administrators to do is to allow all teachers to share these things to the Creative Commons with restrictions that Beth was talking about, that somebody can't then take it and sell it, which is the opposite of what happens on Teachers Pay Teachers. The school is saying, we'll allow this to become part of this greater commons in Nebraska, which is, eventually hopefully aligned to NDE standards. So the non-commercial share alike is the board saying, send this lesson plan out there to the world, and maybe somebody will make an even better tweak to it, and now we can get that back, giving attribution down the chain the whole way. Then the attribution non-commercial no derivative part would be, we have this awesome thing, NDE has said, that's great, that's aligned to standards. Now maybe we don't want people to change it because the act of saying it's aligned to standards might be of significance to your board in setting the curriculum. So it allows both of those two things to happen while not, giving away the farm, so to speak, in terms of the rights and care of the stuff.
So, all right. So what we have been working on then as, again, a partnership between the Department of Education and ESUCC is what I'm calling a platform, and it's called OER Commons. And you can find this oercommons.org. And we did a lot of research on, so what types of places can we do this sharing? Where can we go to provide opportunities for classroom teachers as well as students to access these resources and to build these resources together? So we were talking with other states and what were they using, and OER Commons really popped up as meeting all of our needs. For a number of reasons. Obviously, you see here, low cost was one of them, easily accessible, and the timely thing, the timely piece, in my opinion, is so critical because we can now go in and edit and change those resources on the spot. So if we made some kind of standard change, just a little tweaking in a standard, we can now also adapt or make changes to our resources in OER Commons. And if we're all looking at the same resources, it'll make a statewide change. But what we see is that, when you think about Pinterest or Teachers Pay Teachers or other types of repositories, they may not be aligned to our Nebraska standards. They may not be vetted by our classroom teachers. And so we feel that they may not be the best quality of resources that you can use. And this is where the Department of Ed is really coming in and doing work with our classroom teachers and curriculum groups to do that type of thing. And so within and Nebraska has what's called a hub within the OER Commons. And again, here is the OER Commons look, and this is what you would see if you were to go to that website, but this is Nebraska's hub. So this is where we have financially, put in some dollars to create this hub for our Nebraska teachers to vet and to align our curriculum or our resources to those high quality standards. And so I've given you how to get to our hub. You see it's oercommons.org, and then you have to put /hubs/Nebraska. You can get to it and apply to be part of our hub, and then you can find those. So we're just getting started with implementing this hub and building the resources within here. So this is really on the ground level. And I know that perhaps some of you are working on this OER thought, maybe Go Open or Future Ready or some of the initiatives that your schools are working on. And we want to make sure that you understand and know that this hub is available to you for your teachers to use also. So I would suggest reaching out to your ESU colleagues and get some instruction and direction on how to get started, how to use that, and so forth. But what this really allows you to do is, you'll see this is a combination of different things. So we have our Nebraska hub. You'll see that in the top left corner. And you can also find other hubs. So as I said, that we had been looking into other states and what the content that they have. So you can do that as well, look at other state hubs. You can add your own resource. You see that kind of in the upper right-hand corner. So anyone can, once they have an account, can add a resource. It may not be in our hub, but they could add or create a resource of their own. And then towards the bottom, you see in the center, you see the groups. So we do have a number of groups already created in our Nebraska hub. And this is where that work would start. So the PE teachers have met. Some PE teachers have met and have vetted some of the resources in actually in OER Commons and aligned them to our standards, and determined using a rubric, an evaluation type rubric, determined what we would want to have included in our Nebraska hub, and then it was endorsed by our NDE. And by doing that, then it becomes available in these collections. So OER Commons and our Nebraska hub is I don't want to say complicated, but it has different levels of resources. And so if something is in our collection, and this is our ultimate goal, is to have these highly vetted, high quality resources to be available in Nebraska's hub collection. And so that's what we're working on. And then again, as I talked about, you can do work. So you can do some of your collaboration work in these groups. And we would suspect that some districts perhaps might even want a group of their own, or some ESUs might develop a group and then organize that for their school districts. But again, if you're interested or you're working on any of these OER types of resources at your school district, I would suggest reaching out to your ESU contacts and get started that way. But anyway, the 5 R's, we used to have, the 3 R's, but now it's really the 5 R's of a Creative Commons. So you can create your own resource and retain that. Obviously, you can reuse somebody else's, you can revise, and I think that's the awesome piece of this whole thing, is that I know that Bobby Toohey makes great resources, so I want to go pull his work and then add my customization to that. Or I can pull both of your types of resources and bring them in together. So, and then always thinking about how to make this better and sharing it. And I think that is where our world is that it's not our tunnel vision and just us working alone. We really have to have that mindset about how do we do this better together.
Yeah, absolutely. A couple more quick points on that. Number one, I think one of the ways that I've had a few boards that have asked questions and administrators ask questions about it is, well, so you're saying that this could ultimately be a cost savings mechanism to our district. I think absolutely. And that's a value neutral assessment on my part. You do whatever you want as a board. But I remember listening to Dr. Ken Fossen talking a couple of years ago at one of our conferences about the Millard math curriculum that they developed and being willing to share that on OER Commons. And so this is something that's happening. There are states out there that have enormous, in some cases even statutorily required repositories. So to the extent that we're sort of on what I view as at least a little bit of the cutting edge of making this a statewide effort and having the right people involved, we got a bit of a field of dreams scenario. I think if we build it, they will come type of thing. Because there are other states that are fully launched years into this and have really well populated collections and things. So we're working with the Department of Education to make sure that the vetting process doesn't run afoul of any of the other copyright interests. For example, if you've purchased Saxon Math isn't going to want you to share that stuff on OER Commons. That's not going to be permissible. So there are some considerations about knowing that what you've populated in and of itself is something that you should even be putting into the collection. That's just one example of sort of thinking through the back end part of this. But I mean, ultimately, I think it's something to be excited about, and it's something that is happening out there across the country. So,
and in terms of that cost savings, yes, the resource itself might be cost, but I think that would allow for you to then provide financial resources for your teachers to really start to develop that content also. So currently we're spending all this money on our textbooks and so forth, and we don't have enough time to give to our teachers. So if we can flip that I think that's what a number of schools and states are doing or considering is how do we flip that and give, you know, those opportunities for our teachers to then vet or to develop or create the content.
Yeah, and so I'm sure Beth would be happy to take any questions that you've got on that. Our plan also is to continue working with other groups out there. We'll work with the guys from the Perry firm, with NDE, and make sure that there are no, you know, other issues that we ought to address. But if you've got any questions from the legal side or from the practical side, let us know.
Yeah, very good.
Cool. Well, thank you, Beth.
Yeah.
We'll keep trucking along here. So thanks to Beth for being helping us troubleshoot our technology issues, being the communicator on our messages, and with that, we'll keep trucking along here to make sure we get done. We are somehow magically pretty much on track. So the answer to back to the hypo is, and the reason we put OER Commons where we put it, is I think how this teacher went about doing that answers the legal question, right? And so the question of, did that teacher technically violate the school district's copyright interest by selling it on teacher pay teacher, is probably yes, unless there was some sort of written authorization and it went to something like OER Commons and not teachers pay teachers. So there's a lot of stuff in there really, but the concept of agency law, did they do it for our purposes? The employer answers the initial question. What can be done with it after that is completely up to the board. So that's where the policy side of it, thinking about you know, how that sort of thing is developed in your district, is important. So yeah, I think it's a problem unless there's an authorization in writing, such as by a policy or contract.
Last thing we'll say on this, our firm also represents ESUCC, and so we have policies for school districts and for ESUs that we will push out to subscribers probably yet this week. And everybody else, we're going to do a blog post that explains this. We were holding off to do that until after this webinar because we wanted Beth to have a chance to show you some of the awesome that is OER Commons. And so I guess our goal is that if you're not the superintendent and you're listening to this webinar, that you go back and share with your upline administrators why it is so important that you get a policy in place that allows you to share your stuff on OER Commons, because you can see this is going to be to the benefit of the entire education community.